Hey there everybody, it's Chris. This is a video series on the contract documents, and today we're going to go over the exclusive right to sell. This is an armless document, and it is a contract between two people. It's a contract between the listing agent and the seller, and this is the contract to sell their house. There are multiple types of listing contracts. There's open and exclusive agency, and this one exclusive right, and that kind of stuff. I'm really going to only go over the exclusive right because that's what we want to. That's really what our office prefers. It's the one that protects the agent and honestly protects the client the most. If you have questions about those other documents or other, feel free to ask. We can dig into them, but this is the only one I'm going to go through in videos. All right, so straight up, first off, it is an armless document, so it's accessed through Armless or through the Armless libraries in DocuSign or Dotloop or Sky or whatever you're using. So access it through that for digital, or of course you can get it straight from the source if you need to. All right, so page 1 is basic information about what's going on here. So this is an exclusive right to sell. It talks about it in consideration for the acceptance of the undersigned license to Arizona real estate broker. We are going to endeavor effect a sale or rental of this property. So you check sale or you check rental, and or you check both of them, or the third box to mean sale or rental. So it has a beginning date, that's right here, and an ending date. Every contract, if you remember from your contract class, has consideration and a beginning date and ending date. So that's your first area to fill out there. I just want to make sure we touch base on that. And all right, so the next part here, part 2, is the sale, is the price, right? So sale price, rental price. If you're not doing it for rental, then don't fill this out. Put a sale price in there. This is, of course, what it's going to start at. As a rule of thumb, when we have our listing conversations with our sellers, I really talk about strategy versus price, right? So it's not we're going to sell it at $350. It's we're going to start at $350, and here's our strategy of how we deal, how we react after that. So make sure you note that to your clients that this is the starting price. This is what we're looking at to start at, and we're going to keep going from there. Right here, premises, the local information or the location information. So street address, that's great. The legal description, the assessor number. These things can be found from your county assessor. Here, I'll show you real quick, or from Monsoon. Go ahead and I'll show you real quick. If I search for this, here is. So I've got my assessor number right there. That's it. And my legal description would be Stetson Valley parcel 34 MCR 789-46 lot number 21. So there's lot and block. This right decides where it is, this decides where to look, and this decides what specific lot where to look. So that's all I would need, right? So I would say lot 21 of Stetson Valley parcel 34 MCR 789-46. So that's what would go right here. This is basic information to help your sellers out to figure out what stays and what goes, right? So fixtures and personal property. All of these things stay. Now, if they're like, oh no, I want to keep all my speakers that are flush mounted, right? Say, well, we can do one of two things. We can either remove them all right now and replace them with something that can stay, or we can actually note in the listing that these speakers are not to convey. Here's some additional things that typically are the choice: refrigerator, washer, and dryer. So these are things that they can choose whether or not to leave. Any additional items, anything that's not included in the sales, this is where they would put in the chandelier does not convey. All right, this last little bit, access and lockbox. On this page, this is where they've given you permission to gain access to the property and put a lockbox on it. So you're gonna have your owner initial, whether they do or do not have access to that. Now that is the first page, and then owner initial is the bottom of the first page also. Second page, agency relationship. It basically defines that the agent is the agent of the owner, and that our firm is and is an agent of the brokerage. Section 6. Section 6 is where we get to compensation. The retainer. Broker acknowledges
received a non-refundable retainer fee of blank. Not commonly used, but something that is used occasionally in the system. It's typically used, where I've seen it used before is with investor clients, where they're going to be doing a lot of work and a lot of, they've got a bunch of properties they're going to list, a bunch of things that are going to go on. So you have a retainer fee that just, this property has a higher likelihood of falling out, but you still want to get paid for your work for that. So that's what the retainer fee goes. On typical transactions, that's pretty unusual. Commissions for sale and for rental. So this is, you're defining what that commission is. And notice it says for sale, it's got a blank, and then it says of the purchase price. So right in here, all you would need to write is 3%, right? Or 6%, or 12%, or whatever, 10%, whatever it is that you are that you're putting as a total commission, including everything that would go to a cooperating agent. So just like a lot of listings that are on the MLS now, or a lot of listings that I've taken before, maybe I have had them pay me 3%, and then I also give 3% to the cooperating broker. So 3 plus 3 is 6, so 6% would go right here. All right, and this, and then for rental, you would define what that is also, if that's a percentage, if it's a flat fee, whatever it is, right? Notice that this is a contract term. So if you put in a percentage as a rental, it's a percentage of the value of the contract. If they're renting it for $1,000 a month for 12 months, the value of that contract is $12,000. So adjust your percentages accordingly. And this is if there's holdovers or renewals of rentals or something like that, then the owner will pay a commission to this. It's basically if we rent out one at $1,000 a month and for a year, and then at month 13 they renew, does the owner pay me a commission for that renewal? Depending on your property management agreement, or if you have one, or how you're working with them, that may be another $150 or $200 or something like that, because you're still responsible for bringing them that client, and they're getting more contract value out of that client that you brought in. Section C, cooperation with and compensation to other brokers. This is where you're defining how much of that is going to your cooperating broker. So we're going to cooperate with all other brokers. It's in the owner's, except when not in the owner's best interest. That's rare. So check mark right here. You got to check in the case of a purchase. Again, if you're not leasing, you don't worry about this second part. So check mark right here. And in the case of a purchase, to offer compensation in the amount of blank % of the gross purchase price or blank. All right. So you're going to put in that example that I had before, where it was 3 and 3, you would put a 3 here, right? So up here on line 69, on this one, you would have 6%. And then on this one, in this blank on line 79, you would have 3%. I hope that makes sense to everybody. All right, payment from escrow or rent. That basically they're going to pay out of an escrow if needed. If there's a purchase by tenant, if there's a tenant in there, the tenant actually purchases it after so many days, then we're still due a commission. This is after expiration. Section F. So if this listing contract expires, here's the reality of it. So after expiration, it just means that even after this contract expires, if somebody who has looked at this property during the contract period, if they offer after it expires, then we're still due a commission. Now, also what that means, and how this is best explained to an owner, is that even after this, if this contract expires and somebody comes back to you and says, hey, or comes back to the owner and says, hey, I'll buy your house, the owner still gets your agency, still gets your employment. You basically get to jump back into the job and get employed as that listing agent. And that's only for people who looked at it during its actual live listing period. So it kind of protects them from people just waiting until it expires and then going after them. We still have a responsibility there and agency there. This is an important part that's rarely used. If a completion sale rental is prevented by default of owner or with a consent of owner, by default or with the consent, and the entire sale or rental commission as appropriate shall be paid by broker owner. This line right here basically says we
Our job is to bring a good and valuable and capable buyer, right? If the owner actually defaults or the owner agrees to cancel the contract, that's not our fault. Then the owner technically is still bound to pay us a commission. If the earnest deposit is forfeited in any of that cancellation, then the owner shall pay the brokerage fee equal to lesser of 1/2 of the earnest deposit or the full amount of the commission. So we're either due half of the earnest deposit or our full commission if the owner decides to cancel that contract. That's a section that is rarely exercised because technically you still want to maintain them as clients. If a contract canceled, then you really just want to go out and get another contract. I imagine if you start fighting over money with them, you're not going to get that listing again. So I would say use that phrase, this clause with much discretion. All right, this construction, it means it's built under the typical laws. Listing broker obligations. This says that what we're going to do, we're going to put a sign in their yard, we're going to talk about it, we're going to broadcast it, we're going to put an arm list, we're going to market the premise. This section D is where the owner can opt out of things like putting it on the internet and putting it on the internet and broadcasting it out there. So you want to be able to, if people really want the best chance to get their house sold, of course, you don't want any of these opt-outs there. Now, if they are, let's say they're a high-profile person or it's a very specific property that they don't want broadcast, then if they check these boxes, that means you have corresponding boxes in arm list when you list this that you will need to check to opt out of those things, opt out of that broadcast. All right, moving on down here, role of broker, that we are not responsible for the premises or anything like that. We're going to have more documents and that kind of stuff. We're going to use escrow title companies. We are a realtor, and you're a member of blank association. So if you're a member of Phoenix, right? Phoenix, you're a member of Scottsdale Association, right? Scottsdale, you're a member of the other one, right? Any of them, right? Which one you're a member of. This tells, Section 11 tells the owner what their obligations are. It's basically keep the property up, keep it up, keep your payments paid, don't incur unnecessary liens or any encumbrances on the property, and that they're to complete a SPUD statement. So that's what they want to do. They're going to apply, Section F here talks about the FERPTA. If they are a foreign person, then they need to comply with that. If it's built before 78, they're going to do lead-based paint. And if the property is an unincorporated area, then they need an affidavit of disclosure. The owner is to have insurance on it, and this just basically says the owner can sell the property, that they've told you everything that might adversely affect, that they've given you everything, all the information correct. This section D basically just says that all the information, all the listing information, all the pictures, all the video recordings, everything like that, that the sellers can't charge us for any of that. That basically we have the non-exclusive, irrevocable worldwide royalty-free license to use it, to publish it and throw it out there, subject to any limitations that were defined up in Section 7 where you check the boxes. All right. Section 14, utilities are stay on. Section 15, basically the broker doesn't have any liability over it, and you're going to hold us harmless. And Section 17 basically says that we are the sole agent of the owner, no matter where the offer comes from, and it's not possible for that the premise can be broadcast to absolutely everybody encountered by the broker, but we will do our best. This is legal stuff, attorney's fees, deposits, recommendations. If we recommend somebody, it's not really, they have to do their own investigation, evaluation of any contractors. Subsequent purchase or lease officers, not a place where you're going to check. Section 21. So this basically, what are you going to do with backup offers? Are you going to accept backup offers? You're going to withhold verbal offers or withhold all offers once the owner accepts purchase of the lease of the contract. So accept backup offers is probably the most common. Just means you're gonna bring in some backup offers. Withhold verbal offers just means that if anybody says, calls you up and says, we would totally offer $345 for that, you say, thanks, I appreciate that. You can put it in writing and I'll present it. Or the third one is withhold all offers once owner accepts a purchase. So once you're under contract, what that just means is that you're going to hold on to it. You can tell the owner, we have other backup offers, but you've instructed me to withhold them. So they'll just be withheld. They don't have to present it. If you don't have that third box checked, then no matter what other written offers you have, what other offers that come through, you must present those to your seller. All right, equal housing opportunity, time is of the essence, all this kind of good stuff. That's all pretty standard. Additional terms. This is used a lot in listing contracts. One of the most common additional terms is basically listing to go live in the MLS upon written notice from seller. What that does is by blanket statement of this contract, it says that the listing is live now, meaning it should be in the MLS and up and running right now. Oftentimes we're talking with sellers and talking about, well, let's get it signed, we'll get it marketed, and we won't actually put it on the MLS for till next week or for 2 weeks or for 3 weeks or something like that. That's technically in violation of this contract and in violation of your armless terms. Now, if you have it written in here where it's not going to go live on the MLS until written notice by the seller, then you've put those terms in there to make that okay. Please remember that the NAR code and armless have a very strict rule that basically says that if you start marketing this to the public, meaning anybody that is outside our individual brokerage, if you start marketing this to the public, then this needs to be in the MLS in 1 business day. Got it? So you can't tell them, you know what, I'm going to send out emails. We'll put a sign in the yard and I'm going to knock on your doors all around there. I'm going to do that this week. And then next week I'll actually go live in the MLS. That is a violation. That will get you fined. So the MLS has an option to manage this. It's called the delayed status or coming soon. So that's something we'll get into in a different video just to talk about what is coming soon and how we manage that in the MLS. But if you want to be able to market this to the public, basically if you want to put a sign in the yard, you want to knock doors, you want to send out a mass email, but you don't want it full on live in the MLS, then it needs to be in coming soon status within 1 day of you broadcasting this to the public. All right, the last page is signatures. Obviously they have to sign it. The sellers have to sign it. What is important is that you also have to sign this. This is a contract between you and them, right? So a contract needs some terms, needs some sort of exchange of value, and needs signatures. Needs both. Everybody signed on it. So it's a bilateral contract that needs everybody's signature on it. So don't forget your signature on your listing contracts. All right. Well, that blew through this listing contract in an amazing a lot amount of time. So if you got any questions, of course, please give me a shout, call me, talk to me, and go get these things filled out. Go take some listings. All right. Thanks again.